This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Hello and welcome to the 6th season of Murgitroyd's Innovation Talks podcasts. We're delighted you have joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or contact us via Twitter @Murgitroyd. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hi everyone, my name's Elaine Taylor-Shaw. I'm a patent scientist at Murgitroyd and I'm here today with Rosie Hardy, director at Murgitroyd, and we're going to follow on from our first part in the series of ownership with part 2. So we've got some really interesting questions and topics to get through today. So hi Rosie.
Hello Elaine, thanks for this opportunity. I'm really looking forward to talking about patents, and the topic today I think in a nutshell can be considered to be am I bothered, because ultimately we're considering why patents are important and what they can give you and why you should really go after protecting your inventions with patents.
Great, so let's get cracking.
Just to cap, we've talked about why we need to think about who owns the invention and the fact that that's the inventor initially, or unless there's an agreement or a rule of law in place that has been transferred to another person, be that a natural person or a legal entity. And then secondly, we've thought about who then owns the right to apply for the patent protection of that invention. Another comment that I want to make is when there are patent ownership disputes, the Patent Office or the courts will consider, first of all, who the inventor of that invention is, who owns the invention, and then if there are any agreements or rules that have transferred the ownership of the invention to somebody else. And so by establishing who owns the invention, they then can work out who owns the patent.
That's great. So I've now figured out who owns the patent or patent application. So what can I now do with the patent now that I own it?
Going right back to what we were saying at the very beginning, a patent gives you control, and that is very valuable because you can then choose what you want to happen to that invention and how you want it to be used. The patent can be used to generate a revenue, so that's through license payments or royalties. It can be from the sale of the patent, or you can obtain security against the patent, or you can use the patent as an intangible asset of your business to give the business value. One thing that's often overlooked is that you can reduce your corporation tax bill using Patent Box, and we'll come back to that in a moment. So a patent protects the invention, and the scope of protection is defined by the claims in the patent document. And so if there's ever any question over what the patent protects, what you do is you always go to the claims and you look and you scrutinise and analyse those claims. And the patent creates a protective firewall of control around the invention as set out in the claims. That means then that the owner of the patent has a monopoly over the invention and can control what happens to it. Now, a patent can last for up to 20 years, providing you pay your renewal fees. So you have this control for a 20-year period, which gives you obviously a long time period for monopoly. Then how you choose to control it is up to you. There are various different ways in which you might want to use your protected invention. So you might want to choose to share your invention without restrictions or on preferential terms. We know about the pharmaceutical companies that have developed and manufactured AIDS drugs and how they've chosen to provide their drugs on preferential terms to certain countries. They can do that because they've got patent control over their drugs. You might want to control your invention using your patent to keep your invention as your USP, your unique selling point for your business, so that you can use your invention to help build up your business and generate an income stream from that invention. Effectively, what you're doing there is you're saying, I'm going to use this invention for my benefit. I'm going to stop others from using it. I'm going to restrict them and have a restricting control over what others can do with it. Without a patent, you have no control. And that means that the invention is freely available. And it means then that your competitors can benefit from the innovation that you've created, the invention, and all the investment that you spent and put in, the time and effort and the money that you spent actually working and creating that invention. I worked for a client once where great business, coming up with lots of great inventions that their customers loved. And they had an arrangement where they were asked to create a particular product for a customer, but my client didn't protect it with a patent. And they saw that particular product sail away, unfortunately, quite literally, because there was no control in place to stop the competitor from taking the product and having it manufactured by somebody else and being able to use it without any controls from my clients. And it was a hard lesson, actually. It was a difficult case to watch as a patent attorney. And it taught me a lot about the value of patents and how they need to be used strategically in business. So the patent gives a restriction to control others. And that means then that others can't use the invention without your permission. And you can enforce your patent rights if people are using the invention without permission. And that's sometimes referred to suing for infringement. And the infringement is assessed by the national courts. And the infringing actions, so the things that you can stop people from doing without your permission, can be selling a product, manufacturing it, importing it, offering it for sale, storing, supplying an essential element of that invention when you know that it's going to be used and intended for putting that invention into effect. There are ways in which you can go about enforcing your patent rights if somebody goes and takes your invention without your permission. And you can also be awarded damages for the loss that you've suffered as a result of that infringement. What you might do is you might find an infringer, and instead of falling out with them, you might actually form a positive relationship and turn it around and grant them permission to use your invention in particular ways. And you could ultimately end up setting up a license agreement with somebody who is interested in using your invention. And licenses can be bespoke to the particular nature of the invention. So they can be exclusive or non-exclusive. They can be based on a particular type of action in relation to that product. So, for example, you might have a license for manufacture, or you might have a license to sell a product. You might have a license that's specific to a particular location. For example, if you have patent protection in the UK, you might have a license just for the UK, or a patent in China, you might have a license specific to what you will permit to happen in China. And the license can be time specific as well. Always look at those agreements as bespoke and specific of what you want to achieve. You can also sell your patent because, again, going back to this idea that it's personal property, you've got the idea of being able to sell an invention and the patent rights on. And again, that's an agreement that must be in writing and signed by all the parties so that that assignment can be demonstrated. And we always recommend that the assignment, the selling of a patent from one owner to another new owner, is recorded at the patent offices. Now, after the exhaustion and jubilation of negotiations, the actual recording of new ownership, the assignment, is sometimes overlooked. And unfortunately, with business change names and with change of staff, if you fail to record your assignments at the patent office so that they are listed on the patents register, it can become problematic. So we always recommend that the lawyers are instructed to record the assignment once the agreement's made. And then a delay in recording that assignment can also be problematic in the sense that your ability to recover costs for litigation can be limited or restricted if you have delayed in recording the assignment or an exclusive license beyond the 6-month period. And then recording an assignment or license on the patent register ensures that any subsequent assignments or license which may conflict with the earlier agreement would not take priority. So it's a protection mechanism.
Yeah, that's great, and something that people should try not to overlook, and it's such a simple process for the patent attorney to do and record it at the patent office. It's not a difficult job at all.
It is quick and it's straightforward and relatively cheap as well. But be aware that the rules and regulations are country specific. So the process in the UK may be different to the process, say, in Germany. But a patent attorney can guide you obviously through that. And we do a lot of those, don't we, Elaine?
Yeah.
The other thing then to think about is the fact that this patent can be used to create value or create an income stream. The Worldwide Intellectual Property Office back in 2020 identified that the annual intellectual property assets were worth over £300 billion worldwide. So the value of intellectual property is large, and people should recognise that having a portfolio of patents makes your business extremely attractive to an investor or a potential buyer because of the control that you have through the patents over your innovation. There's a lovely story of a company called SwiftKey who developed predictive software, and they were then sold to Microsoft for a reported $250 million. It was some graduates who developed this product as a startup company, and obviously it took off and became highly valued as technology. And the value of the company in this $250 million was reflected on the fact that they had protected their technology. And without the patent protection, the value of the business would have been very much lower. And in fact, they wouldn't have had control over the technology. Microsoft could have walked away and used it without any restrictions. Going back then to the idea of making money from your patents, I've already mentioned the fact that you can use it as security to obtain a mortgage or loan or investment. I'm sure that many of our listeners have watched Dragon's Den, and we've seen those poor people go into the Dragon's Den, but then come up with the news that they have protected their innovation. And you can see the change in response from the dragons when they talk about that, because they know then that they're dealing with something that is protected, and it's of much more interest to an investor then. There's always going to be due diligence behind that security assessment, where what you will do is you will look at the validity of the protection and the value of the patent. And there have been situations where, I know in Dragon's Den, for example, where investors have initially shown an interest and pitched for innovation, and then due diligence have shown that actually it's not as safe and secure as they first thought, and so investments fallen away. And then finally, patent box. In the UK, we have a really good, advantageous tax scheme called the patent box tax scheme, where your worldwide profits earned from a patented invention can be subject to only a 10% corporation tax rate, which is much reduced from the standard corporation tax rate. And that can mean you can make an enormous saving on your worldwide profits. There are rules. There's always rules. And so speak to your patent attorney and speak to an accountant that specialises in patent box tax schemes so that you can set up your intellectual property, your patent rights, and you can set up your business properly to take full advantage of that.
Yeah, that sounds really good, especially for small businesses or individual inventors. You've said about owning a patent and what value it has in terms of it being an asset to a business or an individual. So can multiple people co-own a patent?
They can, yeah. That can be multiple natural people, human beings, or it can be multiple legal entities. And there can be one or multiple owners of that patent right. The owners have what's called an equal and undivided share, unless there's another agreement in place which changes the division of the ownership in a different way. What could that agreement look like? Well, it could be an ownership agreement which divides the responsibility of who pays for the fees or who can do what with the invention. And that could be location or role and purpose behind the use of the product, the use of the invention. So a little bit like a license agreement and the considerations of a license agreement. As co-owners, you both have to agree on what happens to that patent application and what happens to the patent. So you do have to consent together to any changes that are made to the patent application or the patent. You have to consent together on any license agreement or sale or mortgaging of the patent. And you've got to remember, it's a 20-year marriage. That's a long time. And sometimes that marriage can go through its ups and downs, and sometimes you may fall out over what you want to happen with that invention, and there might be some tricky negotiations. The business may change. The need for the invention may change. The value of the invention and the patent may change. So you've got to always remember that co-ownership is not necessarily straightforward, and it's something that you do have to think very carefully about and be flexible and always check in and say, are the terms of our co-ownership right for now, and revisit that. The courts and the UK Patent Office can deal with disputes over co-ownership as well. And they do have the rights to be able to grant licenses in a co-ownership dispute to try and minimise the grief and soreness. So there are lots of issues, but effectively you've got to understand that you are working in tandem and you both need to be in agreement with what happens to that patent.
That's great. I think that's everything about ownership, or at least a snippet of topics on ownership. Obviously, there's a lot more to discuss. That's great, Rosie. Answered all my questions quite in depth, and hope that people find the information useful. So yeah, this concludes our second part of this 2-part series in terms of ownership. I'm sure we could talk for hours on ownership and the different topics that lie underneath. But yeah, I hope that's given people a snippet into things to consider and things to think about in terms of ownership. So thanks very much, Rosie, for taking the time to talk to us today and for answering all my questions.
Thanks, Elaine. It's been really good to talk. I hope people realise why I'm so evangelical about patents and can understand a little bit more about why they're really worthwhile. Please feel free to contact us if you have any questions. Rosie Hardy or Elaine Taylor-Shaw, we're both based in the York office. We'd be more than happy to answer any question. And You've probably started to realise that patents are a bespoke issue and you're playing a game of strategy that is very particular to your business, and your patents are all different and the reasons why you want them is different too. So we'd love to help. Thanks again.
Yeah, thanks.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.